As we are all aware, we have a Human Rights Act now here in Queensland, and it commenced at the beginning of 2020. The Act is the third piece of human rights legislation in Australia. We follow the ACT and Victoria, two other states who introduced human rights legislation before us. So we do get a place on the podium. We get the bronze medal. The Act lists 23 human rights for legislated protection, and those human rights come from modern human rights law, from international understanding, from the atrocities of World War II, when the world said never again. In our country's history, we have signed a lot of international human rights treaties, but it is only when those human rights in those treaties are incorporated into domestic legislation that they can be properly protected. There are a few unique features to Queensland's Human Rights Act that sets us a little bit apart from the ACT and Victoria. They all have a similar model. The one thing that we're focused on today in this workshop is the fact that Queensland has a direct complaints mechanism. So that means, as we'll get into the slides, that people can make a direct complaint about an alleged human rights breach, and that can go to the Queensland Human Rights Commission, but I'll hold fire on that for a moment. As you can see on the slide, our human rights legislation has three overarching objects or goals. And to protect and promote human rights. Building a culture of human rights is a long-term goal. It's not going to be something that is going to happen overnight throughout the government service delivery, but it's really, really crucial that our sector's ownership and use of the Act in holding government to account is going to be a critical ingredient for the development of that human rights culture here in Queensland. It's worth mentioning, I think, just in terms of the framework of the legislation, that it promotes what is called a dialogue model. And you can see that there on the slide. A dialogue about the nature, the meaning, and the scope of human rights. So what does that actually mean? Because it's quite a legal concept. It means that those three different branches of government, our legislature, our courts, our tribunals, the judiciary, and in the middle, you can see public entities, the executive, those three branches of government are in dialogue. They have a discussion with each other about human rights. The courts here in Queensland under this model, they do not have the power to strike down legislation that is not compatible with human rights. That's a different sort of model. It's a more American model. When we hear about the power of the US Supreme Court to rule that legislation violates rights in the Constitution, that is not how the Human Rights Act works here in Queensland. It's not that type of approach. A dialogue model is gentler, and it doesn't give courts that level of power. In fact, the power really sits with Queensland Parliament and the sovereignty of Parliament in the way in which our Human Rights Act is structured. So Parliament, the executive and the judiciary all have different functions to promote and protect human rights. We are very interested in that middle box there, public entities. That's us. Community organisations, when we receive government funding to deliver services, we are an extension of government in that way. That is how it is understood. We are part of the executive branch when we are acting with public money to deliver those services. So that means that we have human rights obligations under the legislation. And that means that we have to give proper consideration to human rights when we make decisions or actions that impact upon people. The legislation actually expressly mentions funded housing and homelessness services as being administered by the state government to be public entities under the legislation. So it's pretty explicit. You can't get clearer when you're expressly named in the actual statute itself. But if you think about all public entities, all government agencies now being required to give consideration to human rights when they are making decisions or taking actions of people that we work with and support, people with multiple and complex needs often, that is a big interface with state institutions that are all now required to give consideration to human rights. There's a legal scholar that I really like who once described people who experience poverty as people who constantly bump into sharp legal things that interface across our health system, our mental health system, guardianship. It might be state schools, Education Queensland. The NDIS is caught by the Act and expressly mentioned as well. And of course, our housing and homelessness services. So all of those decisions now require consideration of an individual's human rights. So what is the real purpose of the decision potentially to limit somebody's human rights? Is the purpose a blanket policy? Is it risk management? Is it budget or funding constraints? Is it our systems and processes that are leading us to make a decision? And have we closely considered somebody's human rights in making that decision? If we're going to limit those human rights, is there a better way to do it that is less restrictive? And overall, when we do that balancing act, is it fair and is it going to cause harm? We, at a later stage in a different workshop, are going to delve more deeply into that whole proper consideration framework. That is really not the focus of this afternoon's presentation. So I'll just park that there for June and July, and we can have a look now at the particular human rights themselves that are contained in our legislation. So the Human Rights Act protects 23 specific human rights. In fact, there are more human rights that are protected, but they are clustered in 23 different headings. This slide shows those headings. Down the bottom, there are criminal proceedings and rights that relate to criminal proceedings and detention, which are generally less relevant for housing and homelessness. So we've placed those down the bottom. You may notice, you may already know, that there is no human right to an adequate standard of housing contained within our legislation. So we do not have that particular hook as a protection. However, there are many, many rights that connect off housing and homelessness. The right to recognition and equality before the law, the right to equal treatment in service delivery, protection from torture, cruel, inhuman or degrading treatment. People's property rights have explicit protection. People's freedom of movement, that might come up in the context of a decision to allocate somebody different housing in a different state or territory, in a different suburb. People's privacy and reputation is a very broad right that really goes to people's ability to have privacy in their home setting. The protection of families and children is crucial to having housing protections. People's cultural rights, the cultural rights of Aboriginal and Torres Strait Islander peoples are explicitly protected, and Queensland has the broadest cultural rights protection for Aboriginal and Torres Strait Islander peoples in the state. It is more broadly conceived in the Queensland legislation than it is in ACT or Victoria. The right to health services and the right to education are also protected and can also have some bearing on decisions in relation to a person's housing or service delivery. The other thing to just point out is, of course, human rights relate to an individual, um, not governments, not organisations, not other businesses. If you are in Queensland and you are human, your human rights can be expected to be protected, and that uh, is the case whether or not you are a citizen of Australia located here in Queensland. There is a lot of really useful and accessible information on the Queensland Human Rights Commission website. They are one of our stakeholders that we're working really closely with in the delivery of human rights content. Sally, thank you. You've just posted their website in the chat. People have probably already gone and had a look at their material, but if not, maybe at a later date, strongly encourage you to go and have a look, because we don't have time to really delve into the individual rights in this session. That information is certainly available on the Commission's website.